The last case on this morning's docket. That is case number 110452 in the matter of Kevin E. Dillette.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. As the court is aware, this case comes before it after a hearing on stipulated facts was conducted on April of 2013. At that time, Mr. Dillette presented a probation plan that the hearing panel found was detailed, workable, and would protect the citizenry of the state of Kansas. At that time, the panel recommended that he be suspended for 2 years, but that be stayed and he be placed on probation with a few additional terms and conditions. It's been 9 months. Mr. Dillette has been working his program. He has provided the court an affidavit indicating that he is in compliance. Our office has no reason to believe that he is not absolutely in compliance, and I would ask this court to adopt the hearing panel's recommendation and place him on probation.
Any further presentation for us, counsel?
No.
Do we have any questions?
I have one on
Yes.
paragraph 51 of the hearing report, which is on page 26, indicates that the respondent was to undergo a psychological evaluation within 60 days following the release of the report. Was that done?
Yes.
Okay.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, counsel. Chief Justice Nuss, my client would ask permission to speak after I finish my presentation, which will last maybe 10 minutes.
And before we do that, since we're streaming live on the internet, would you go ahead and repeat for us who you are, who you represent?
Of course. Thank you. Kevin Dillette appears in person and with his attorney, Trey Petlin, and I'm Trey Petlin. The panel report, of course, will reflect that in 2010, Mr. Dillette was placed on diversion for 3 complaints that occurred in 2008. And after initially being placed on diversion, he violated the terms of the diversion with 2 additional complaints that reflected, one of which reflected failure to communicate and lack of due diligence. Areas which the panel found were a pattern of conduct. The restricted practice areas under the probation include, let me rephrase this. There are two complaints that pertain to areas of practice that he is allowed to continue to practice under the suggested restricted areas of practice on the probation. And so 2 complaints that are pertaining to criminal defense cases, and they pertain primarily to non-refundable fee agreements. He had a non-refundable fee agreement as a part of his diversion, and then after he was placed, or I'm sorry, before his diversion, and then after he was placed on diversion, he restructured his fee agreement, but he created essentially a non-refundable fee agreement still. It was called a commitment fee at that point. And it didn't matter, obviously, how it was phrased. The fact that it was non-refundable was impermissible. In that complaint, incidentally, that happened after he was placed on his diversion, as soon as he was terminated in his representation, he treated the fee as an hourly fee. He converted it to an hourly fee for his time, and he came to an agreement with his client after some discussion about what the client should be refunded. 2 of the provisions I just would point out, I think 2 of the provisions in the probation, which is very detailed. We're very fortunate to have a practice supervisor available who's close to my client's office, who's willing to spent a great deal of time with Mr. Dillette, but two of the provisions in the probation might have prevented maybe all of the complaints. Certainly all of them with regard, with the exception, possible exception of one that happened on diversion. The hourly fee agreement, which he's required to use in all of his cases except for his traffic cases, he's implemented that. He implemented that prior to the hearing before the panel. And his practice limitation, which would have prevented him from getting into, for example, a slander case, which is outside of his area of expertise, I would submit. He's restricted his practice areas to criminal defense and collections and traffic defense. As a result of that, in great part, he's reduced the number of cases that he's had, which I think also presents a byproduct that's favorable in the sense that it allows him much more time to spend on each case, and it allows him more time to communicate with his clients. He's reduced his overhead substantially, which was a contributing factor to his stress and his mental health issues. He has obtained the forensic evaluation, which gave him some new insight. That was a condition or requirement of his probation, and that evaluation report was presented to Dr. Deutsch, his counselor, and they are using what those findings were to address the issues that caused many of the problems, or at least were contributing factors for many of the problems, even while he was on diversion. I would submit respectfully to the court that Kevin Dillette does present with a number of wonderful assets. Probably the most notable is that he's committed to improving his life, and he's committed to improving his practice, and he's committed to success, which begins, of course, with successfully addressing the issues that brought him to the attention of the disciplinary administrator in the first place. He's very receptive to outside counsel. He really enjoys, just as an example, the resiliency group through KLAP, and he rarely misses that. He attends twice a month, not just for the therapeutic value of talking to other people that have also had difficulties, but also because there's a great deal of mentorship in that program. And we submitted a letter at the panel hearing from Ann McDonald describing his participation, and I think she was very happy with my client. He also has participated in marriage counseling, incidentally, because he was having a great deal of marital problems during particularly during the slander case, and he let those problems, I think, affect his performance as a lawyer. He successfully reorganized his office in great part. He's reduced his caseload in scope and in volume, and he's responsibly addressing his mental health issues. And there's, of course, been no complaints since he's been placed on probation. I think my client understands that he has made a lot of progress, but this was going to be always a concern for him in his practice, that he's communicating with his clients, that he's diligent in his cases. That's part of the reason why we limited the scope of his practice and suggest that to the court. So he doesn't have a file, for example, sitting on his desk, not getting the attention that it deserves because his learning curve is steep in that particular kind of case, because he doesn't have the answers for the client, so he doesn't respond to the client, even just to say there's been no movement in your case. Mr. Gilman's focus when he meets with my client as his practice supervisor twice a month includes going through all of his cases to determine that they're all within the confines of the restrictions, and to determine whether there's any cases where any clients are unhappy about the level of communication between he and that client. That's a focus. And there hasn't been, thankfully, any recurring problems in that area.
But Mr. Gilman did acknowledge that he doesn't have a way to verify on returning phone calls.
That's true, and I mean, obviously, we're not going to have a situation where someone can be with him 24 hours a day or 40 hours during the work week, but he is able to, and my client, being receptive to this supervision, enjoys the dialogue about each case. He'll ask him about any cases that he thinks that he may have some problems with, legal problems, things related to the probation, but also other problems. Mr. Gilman is a experienced lawyer. He's been practicing since 1991.
It just seems like, to me, there should be some way where Mr. Delick could at least make a record of when he returned the call. The thing that bothers me is that seems to be a fairly common initial indicator. When phone calls aren't returned, that's usually the beginning of some really big problems. So I'm a little concerned that we aren't looking at that so we can catch if there's beginning to be a slide, if you understand what I'm saying.
I do. I think the probation plan is much more detailed than his diversion was with regard to that. That's one step. The other issue that I think that was very problematic for Mr. Dillette was his depression and some of the issues that were related to that caused him to feel overwhelmed. His case numbers were much higher, just as incidentally were about twice as many cases as he has now, and in different areas. And so that, I think, contributed to not returning phone calls. He knows that is a primary concern of the court, and if the court doesn't have any more questions of me.
Yeah, counsel, I want to direct, and this has really got to go to the lawyer rather than the respondent. Look at, if you have it there, paragraph 55 of the panel report, which is at the bottom of page 27, and I probably need to direct this to the disciplinary administrator too. This is a minor thing, but from a practical case management standpoint, I'm worried about the idea of the respondent being on probation even after the 24 months, because he has the suspension hanging over his head during the period of probation, and this doesn't really have any case control kind of thing. So here's what I want you to think about. When I saw that and questioned it, I made a note to myself to suggest that maybe we, in our order, have this case come back to us in 2 years. It doesn't need to be on the docket, but just that you guys would report back to us and tell us whether there's a reason to continue probation, and if there, then whatever the answer is, we can deal with it. And if you disagree, we'll deal with that too. But I guess I don't like the idea of just having this perpetual probation out there without it getting revisited. And I suppose another answer would be to have the responsibility on the respondent to come back to us in 2 years, but it seems like we need some other control than just what's written here in the recommendation. So if you have any thoughts on that, let me know. Let us know.
I certainly would be willing to undertake the responsibility if the court wants to impose on me to bring it to the court's attention in 2 years, and I could put that on my calendar, and or I certainly don't have any objection to just simply putting it on the docket for a review.
Okay.
Any further questions? Thank you, counsel. We'll hear from your client.
Mr. Chief Justice, members of the court, may it please the court and counsel, as a law student, I had always hoped someday that I would be speaking before this tribunal. I just never imagined that it would be under these circumstances. To say that I am chagrined and remorseful for such circumstances would be a huge understatement. I am extremely remorseful for what I've put everyone through in these matters. The worry that my clients must have experienced in not knowing where their cases stood, or the worry that they might not be able to hire replacement counsel if I could not make refund of their unearned fees. The worry that my wife experiences over whether she might suddenly become the sole breadwinner for our family. The countless hours my attorney has spent ably representing me in these proceedings. The waste of judicial resources and those of the DA's office. The onerous burden my practice supervisor has taken on in monitoring my probation, not to mention all the trees that we've killed to write our pleadings. All of this tumult would have been unnecessary if I had simply done what thousands of other Kansas lawyers do daily: follow the rules, attend to their ethical obligations, communicate with their clients, and move cases along to conclusion. I will never forget the words of one of my hearing panel members when I asserted I was a good lawyer. Andrew Ramirez looked down and told me, "Counsel, good lawyers don't find themselves in this room." So I guess whether I am a good lawyer is open for debate, but I can tell this honorable court that I am a better lawyer than I was when these complaints arose. I've become a better lawyer by accepting that I am not Superman. I cannot make miracles happen for clients who want them, or when I think that I should be able to achieve them. I cannot avoid the foibles of other lawyers who suffer from depression or stress or other disabilities. I know now that I am just as susceptible to life as everyone else. I have recalibrated my approach to client counseling, and I work hard not to set myself up for failure by overpromising results to clients or by setting my own unachievable goals for those clients. One of the complaints before you involved a case which I should never have taken on to begin with. Mr. Petland referenced a slander case, but one that I probably could have swiftly and successfully resolved if I had just fully understood my client's goals from the beginning. Not to have a slander litigation, but simply to get an apology from the supposed offending party. So I'm doing a much better job now of establishing goals and expectations at the inception of my client relationship. I've become a better lawyer by implementing a structured probation plan that increases my accountability through oversight of my practice supervisor, Frank Gilman. In addition, he provides constructive criticism. He serves as a sounding board for possible methods of resolving cases. He brings a different way of looking at things and resolving things. And he's also a businessman, having managed his own practice for many years. And I am learning to make better business decisions, which directly impacts upon my abilities to competently, zealously, and diligently represent my clients. Mr. Gilman has been a friend for nearly 19 years, and I am very much enjoying this added dimension to our relationship. Over those many years in practice, I now recognize I had grown overconfident in my own abilities and somewhat sloppy in my approach. This despite the fact that I am a perfectionist. Adherence to my probation and development of markers of accountability, and this goes to Justice Johnson's comments about being sure that telephone calls are returned. Development of markers of accountability in my files has actually made me a better lawyer. Now my timesheets reflect that calls are received, that calls are returned. If messages are taken on a pink slip, typically I try to write on the back of it, call returned such and such date and time, topics discussed. This accountability has made me more attentive to the fine details of cases that often make or break, better about communicating with my clients, even the bad news that sometimes we all have to communicate, as I should have in the slander case, and better about detailing my timesheets and notes about what actions have been taken. So now if a client chooses to take his file to another lawyer, or if I am suspended for any period of time, or God forbid, if I get hit by a bus, successor counsel should be able to pick up my file and better able to run with it, knowing what has been done. I'm better managing my caseload, which is lower, as Mr. Petlin observed, permitting more time to attend to the details of each matter. Through the years, my cases have ranged from traffic tickets to homicide in municipal and district courts, from Dodge City to Baxter Springs to Atchison, all across Kansas, federal courts from Wichita to Omaha to Springfield. I know I have helped many hundreds of clients over the years, many repeat clients, many who came to me on referrals from other satisfied clients, referrals from lawyers, and people in the criminal justice system who know how hard I work for my clients. I truly care about my clients, and I love the practice of law. I know I am a much better lawyer for having had these complaints and responded with the changes I've discussed. There is still so much that I hope to do with my practice. Many important open files are pending in my office right now, and I simply ask the court to give me the uninterrupted opportunity to continue serving my clients and making a positive impact in our judicial system. I'm very proud to be a Kansas lawyer. I don't intend to leave the practice of law like many lawyers who get stressed and burned out and face disciplinary action. I'm extremely, extremely humbled to appear under these circumstances, to have my name called on a docket, to sit at this table, to know that there will be a reported decision. I'm extremely humbled. I thank you all. I thank Mr. Petlin for his efforts. I thank Ms. Knoll for her efforts to improve my practice, and I appreciate your time today. Does anyone have questions?
Any questions of council? I see none. Thank you.
Thank you.
Thank you all for your remarks this morning. Court will take this matter under advisement.